Good afternoon, ladies and gentlemen, and welcome to Engineers Ireland. My name is Oliver Dalton. I am the chair of the Roads and Transport Society here in Engineers Ireland. Just some housekeeping rules before we start. There's two emergency exits. The one you came in, and there's one down to the left down here. Secondly, there is we're webcasting this, so there's a lot of viewers online. So I'd just like to welcome those people to this afternoon's presentation. This afternoon's lecture is brought to you by the Roads and Transport Society, and I believe it will prove to be a significant interest to all involved in the delivery and administration of construction contracts. This afternoon's speaker is Robert Rooney. Robert is an associate at A&L Goodbody, who are recognised as a market leader with respect to construction law and have been involved in assisting both public and private clients on bespoke and landmark projects in Ireland over the past 20 years. This afternoon's lecture will focus on the Construction Act, which was enacted on the 29th of July. This piece of legislation aims to impose a requirement on all construction contracts to expressly provide for the amounts of all payments. It also renders a paid when paid clause ineffective, and it gives the parties to the construction contract the right to go to dispute. Finally then, I'd just like to invite Robert to the podium to give his presentation.
Thanks. Oh, thanks, Oliver. So as I was coming in today, I was kind of reminded of previous times I've been in the lecture theatre and in this lecture theatre. The very first time that I was in this lecture theatre was about 10 years ago, and I, as a very junior, had drafted some slides on what was then the big change in construction in Ireland, which was the public works contracts. And the big debate in 2007 was how much the public works contracts were going to increase tender prices by in 2008 and 2009. That was the big concern in this room 10 years ago. So the increase in tender prices in 2007, 2008, 2009 didn't quite materialise, but we've had a lot of change since. So I'm very happy to be back and delighted to be asked by Oliver to come back and to talk. This time to both draft and talk on a change in the construction industry, which is the introduction of the Construction Contracts Act. So the purpose of the talk, I guess, is to try and bring you up to speed with the changes that have been introduced over the summer so that you can administer your contracts and keep your clients and indeed yourselves out of disputes. And we'll have about 40 minutes, or I'll probably speak for a little bit less than 40 minutes. I'm very happy to be interrupted by questions as we go, and we'll also have a Q&A at the end. I'm also reminded that because there are listeners on the webcast, that we have to get microphones out so that people can hear the questions on the webcast. So what we look at today then are three things. Firstly, we look at the aims and the application of the Act, its background, why we're here, what it's trying to do, what contracts are covered by it and not covered by it, and so on. Secondly, we look at payment provisions, and I think that's the really important part of the Act. Most of you guys and girls, indeed, if you, my little sister was one of 4 civil engineers in her class, so she would have given out to me for that. Most engineers will only encounter an adjudication once or twice in their career. Certainly that's the UK experience. However, you will administer payment on a monthly basis. So the changes in relation to payment cycles are, I think, really important for you guys in terms of administering the contract. So I'll try and focus in a little bit on the and spend most of the time talking about the changes in relation to payment. The good news is that they're probably pretty easy to digest and to implement. The bad news is that if you don't implement them, that you increase your chances of getting involved in an adjudication. So what I'll do towards the end of the talk is I will talk a little bit about adjudication to try and give a sense of what your role might be like in an adjudication as an engineer. Can I just get a sense, by the way, of like how many people here, for example, are we'll say either consultant engineers or on the client side in general? How many people fall into that category? Most people, I suspect. And how many people would fall into the contractor category? Okay, so we've got some brave contractors who've come out to bat the contractor corner. And really, the Act, actually, to be fair, is about giving contractors new rights. So they're the three kind of broad headings that we're going to look at today. In terms of, I suppose, looking at why we're here in the first place and looking back at the history of the Act, cash flow in the construction industry has always been a really big problem for the construction industry. And it's been a problem in good times and in bad times. It's not just a creature of recessions. But we did see in 2008, 2009, up as far as I'd say 2011, 2012, serial insolvencies in the Irish construction industry. And one of the things that became really apparent out of the insolvencies that we had in that period was just how reliant the construction industry was on its lowest tiers, on the subcontractors and subcontractors, on the suppliers and their suppliers and the manufacturers, and so on, and how much the industry was reliant on those people for credit and for cash flow. At the same time, there was the perception of a better experience, a better culture in the UK. The UK introduced payments legislation nearly 20 years ago now. 96, I think it became effective in 1998. They had a longer lead-in time than we did. So there was a perception, and I think certainly from my own experience of practicing in the UK and Northern Ireland, I think it's a reality that the culture of payment in the construction industry is a lot better than it is in the UK, particularly, we'll say, between main contractors and subcontractors. So you had then the owner of a subcontracting business. I think he also owned a few other businesses, but one of the businesses he owned was a subcontracting business, Sean Gallagher, who had his business, I think, become insolvent in that period. And I think, and I could be wrong on this, I should have checked before the talk, I think he's from Dundalk. And I suppose the basic question that somebody in that position would be asking is, if I can get protection if I do a contract in Newry, why can't I get the same protection if I do a contract in Dundalk? So he started to promote the idea to TDs and senators that we would introduce payment legislation in this jurisdiction along the lines that they have in the UK. And it just so happened that Fergal Quinn was looking for an idea to promote, for his one chance in the year to promote a private members' bill in the Seanad. And usually private members' bills sink. They're usually an interesting hour or hour and a half of debate in the Seanad chamber, and the bill is never heard of again. But much to everybody's surprise, Fergal Quinn decided that he would introduce a construction contracts bill that would introduce the legislation that they have in the UK, more or less. That was the draft that they had at that time. If that was a surprise, I think the industry was absolutely shocked when the minister actually accepted it. There was real surprise throughout the industry in 2010 when the minister said that he was going to allow the bill to pass through the Seanad. It didn't have an easy passage. It took another 3 years to get through and be signed onto the books by the president. It had one of the most unusual histories as a piece of legislation. It survived two Oireachtas. It only survived the general election of 2011 because Brian Lenihan came in his last appearance in the Oireachtas as minister to speak on it in his interregnum days, and the bill managed to survive, and it was all very dramatic and everything else. But anyway, we got to 2013. We got to the bill going on the statute books, and then nothing happened. So I think certainly by 2014, most people were seminared out. They had heard enough about the construction contracts bill. They thought it would never come to pass. They thought the minister would never commence it, and they were sick of listening to it. And insofar as they had been listening to it, all the talk had been about adjudication, and very little attention had been given to payment provisions. So in February of this year, then, after many false starts and after many indications to the contrary, again very suddenly, the relevant minister signed the order appointing the 25th of July as the day on which the Act would essentially enter into force. So when we started to look then again at the Act, and looking at its implementation, as I said at the start, it became very clear that really the key thing in the Act from the point of view of implementation was actually payment provisions, not so much adjudication, but payment provisions. That's the nuts and bolts of how the Act impacts on day-to-day on the day-to-day life of the construction industry. So I would suggest that there are really two pillars to the Construction Contracts Act. The first is that it's intended to regulate payment cycles, and there's a little diagram down the bottom of payment cycles. But the second diagram is of a shotgun in the corner, and there's a reason for that. The experience in the UK is that adjudication nowadays isn't used very often. Something like less than 1% of construction contracts will have an adjudication in relation to them. But what adjudication has done, its availability has done, is that it has changed behaviour. It is the threat that sits in the corner that everybody hopes never to have to use, because everybody loses if it has to be used. So adjudication, to my mind, is really the shotgun in the corner that forces everybody to face up to their obligations in respect of running payment cycles and payment claim notices and payment response notices and all the rest of it. Okay, so I suppose we better just take a quick look at what falls within the Construction Contracts Act and what falls outside the Construction Contracts Act. Firstly, it only applies to contracts that have been entered into after the 25th of July 2016. So we're only a couple of months into the Act, and one of the things that's still happening is that you have main contracts that were entered into before the Act came into force, but subcontracts that were entered into after the Act came into force. And that causes a certain amount of discomfort for main contractors, but there's, to be honest, very little that can be done about it. The second thing is that it applies to both written or oral agreements. Now, you won't be surprised to hear what a lawyer thinks of oral agreements, particularly in relation to something as complex as a construction contract. But the Act certainly gives a fresh impetus to make sure that your contracts are in place before works begin and that they're committed to writing and so on. The third thing to say about what's covered by the Act is that the definition of construction operations, which is the hinge piece of the Act, is very, very broad. So I was looking through it recently for a colleague who was advising a client, and one of the things that leaped out at him was that it covers maintenance contracts. And not just maintenance contracts, it covers agreements which arrange for maintenance. So obviously in your world, maintenance of motorway networks and that sort of thing, mark contracts, if they were awarded after the 25th of July, would be within the scope of the Act. Another point that sometimes surprises people is that consultancy appointments are within the scope of the Act. So your consultancy agreements with your clients are caught by the Act. Project management agreements are caught by the Act. Probably less relevant in this room, but interior design agreements are also caught by the Act. And the Act applies whether or not the parties seek to exclude its operation on their particular contract. Then in terms of what's outside the scope of the Act, contracts that are valued under €10,000. But one of the questions, I suppose, that the Act leaves open is, well, when do you value the contract? Is it the value of the contract sum on day one, or is it the value of the contract as it increases, or is it the value of the claim that would get the contract into adjudication? So there's definitely a grey area there. My view is that the definition will be interpreted expansively. So if there's any way that the contract can be interpreted as having a value in excess of €10,000, I think that the benefit will be given to the contractor or to the consultant, because that limit at 10k is probably more relevant to consultancy agreements than it is to construction contracts. Employment contracts are excluded, and also supply-only contracts, and there's a couple of things to be said about that. I mean, one way of looking at this definition is, well, does the supplier lift a screwdriver when he gets to site? If he does, that's probably enough installation to get him inside the terms of the Act. But one of the things that we're seeing is that suppliers are increasingly trying to add some sort of install element to their contract so that they get the benefit of the Act. Owner-occupier projects where the dwelling has a square meterage of less than 200, and then finally the top tier of PPP contracts are also excluded from the Act. Okay, so payment, and I keep harping on about payment. There are changes. I think that the changes for where there's good practice, the changes are manageable and really reinforce good practice. Where practice isn't so good, perhaps it might be best to to step things up, because the Act does now give the option of adjudication to a contractor in cases where there isn't proper practice in relation to payment cycles and so on. Sorry. So, looking then at what's changed since July. Sorry, I should just finish this. What's changed since July? Payment claim notices. So that's the contractor's responsibility and really takes the place of the interim valuation. Responses to payment claim notices, that's your responsibility, and we'll talk about that in a little bit of detail. We have some implied payment terms about the frequency and so on of payments. We have new rights of suspension for non-payment, and we have the prohibition of pay when paid clauses. So, how does the Act actually operate? How does it integrate its payment mechanisms into your construction contract? Well, the first thing to say is that there's a difference about how the Act does it in main contracts from subcontracts. In relation to main contracts, what the Act says is you must have an adequate mechanism for determining interim payments and final payment, and you must have an adequate mechanism for determining the dates of payment cycles. Now, if you're using the public works forms, they've been amended to take account of the Act, so you're probably in fairly safe territory in relation to those main contracts. If you're using private form contracts that haven't recently been amended, or if you're using the House special amendments, as a lot of places have, you might just want to look to make sure that your payment provisions in those contracts adequately reflect what the Act requires, and we'll look at what the Act requires for that in a second. So, in main contracts, as long as there's clarity about how you determine how much money is due and when it's due, the Act gives you more or less a carte blanche. In subcontracts, what the Act says is you have to have payment cycles every 30 days. Now, I made it sound easy when I said that in main contracts, the Act gives you carte blanche, because in reality, main contractors will only sign up to terms that are back-to-back with their subcontractors. They won't sign up to, a 5-week valuation term, or more realistically, they won't sign up to milestones if they can't back that off to their subcontractors. So we see, for example, a lot of industries now that are very much milestone dependent, like wind farms or that sort of thing, power projects and the likes, that traditionally would have seen the main contractor paid only at the completion of a particular milestone, and there might be significant gaps between individual milestones. But because the law obliges them to pay their subcontractors on a 30-day, no less than every 30 days, they won't sign up to milestones anymore. And to be honest, that seems to me to be a fair position to take. So I guess what I'm saying is, one of the realities of the Act is that regardless of what your existing practice was, I think we're moving towards payment on 30-day cycles, or cycles certainly no more than 30 days. What happens if you don't have an adequate mechanism, or if you don't state the dates and the mechanism for valuation? Well, the Act has a schedule to it, a schedule in the sense of an annex, but also a schedule in the sense of a program for payment, which provides for the payment cycle to run every 30 days. So the Act has a default if you haven't written it into the contract. So the Act revolves around this idea of a payment claim date, which is the date on which a payment claim notice is required to be made under the Act. And then as you'll see there, the default is that the first payment claim date has to be 30 days after the commencement date of the contract, and then regular payment cycles every 30 days thereafter, and final payment 30 days after the date of final completion. There was a bit of a debate in some circles as to whether or not that final point meant that you couldn't have retention anymore, but I think that people who were heralding the end of retention have accepted that maybe was a little bit melodramatic, and the Act does cope with retention mechanisms, and that final completion can be fairly interpreted as being, a year on or 2 years on or whatever your defects period might be. So I think that issue that arose on some contracts and with some lawyers over the summer has been put to bed. Okay, so as I said, the Act really revolves around this idea of notices, and you have a payment claim notice, which is the contractor's responsibility, and you have a payment response notice, which is your responsibility if you're administering the contract. The payment claim notice has to come in every month, even if the amount to be claimed is zero. It has to state the period, the stage or activity to which the payment relates, the basis of the calculation, and the subject matter of the claim. And as I said, that really does take the place of the interim valuation. It's an interim valuation in all but name. The payment response notice is to be issued by or on behalf of the employer not later than 21 days from the payment claim date. Now, there's a catch here. It's not from the date on which the notice came in. It's from the date on which the notice should have come in. And I think that is catching people out. The Act actually gives the contractor 5 days grace after the payment claim date to get his notice in. But you're timed not from the date on which the notice actually arrived on your desk, but from the date on which it should have arrived on your desk. So definitely one to watch. Now, where does the payment response notice sit alongside the certificate? If you're working on the traditional forms of contract, IEI or AAI, and if you're not amending them, you will have a certificate which sets out the amount of money that the contractor is owed, and you will have a separate document, which is your payment response notice, which sets out the difference between the amount that you're certifying for payment and the amount that the contractor claimed. So that's the payment response notice is only concerned with the difference between the two. Now, there is a little catch with that. The public works contracts have melded the two into one. So their certificate is also the payment response notice, and your certificate will say on its face why you haven't certified the amount that the contractor has paid. Or sorry, the contractor has claimed. And the payment response notice, as I set out there, has to specify the amount to be paid, the reasons for the difference in the amount, and the details of the claim. Now, those last 2 points look very similar, and in truth they are. The second last point, reasons for the difference in the amount, that relates really more to issues around quantum or even abatement, so work that hasn't been carried out in accordance with the contract. Whereas the final point there is really concerned with details of a contra charge or a claim against the contractor. That's the distinction in those final 2 points. Now, the department has published standard forms for both of these two documents that you can go onto their website and get and fill out on each occasion. I haven't actually met anybody who's done that. Has anybody actually used the departmental forms for this process? I do some teaching in Blackhall, and they decided to do a course on alternative dispute resolution. And one of the things that they decided to ask trainee solicitors to do was to fill out the payment claim notice and the payment response notice, which I think was a particular exercise in torture. And I have to say that it struck me that the forms are not particularly helpful, actually. Now, maybe it was just because I was looking at forms as a solicitor being drafted by trainee solicitors, and maybe they make perfect sense to engineers, but you're not required to use those forms. They're there to help you if you need to, but they're a bit clunky in my view. Okay. So I suppose the question then is, what happens if you don't issue the payment response notice? And that's where I suppose you go out, where you fall foul of the Act and these new remedies start to apply. So if you don't issue the payment response notice on time, the Act provides that the amount due must be paid. But unhelpfully, the Act doesn't say what the amount due actually is. Now, if we look to the UK example and what has happened in the UK, it's accepted that the amount due in those circumstances is the amount that the contractor has claimed. So if you're late with your notice, the contractor gets paid the full amount that he's claimed. Is the UK experience, and I'm suggesting it's pretty likely to be the Irish experience as well. So what we're saying there is it's arguable that if there's no response to the payment claim notice, that you'll lose the right to contest the claim, that the amount becomes due and payable, and that your client will have to pay it as a debt. And also, as we'll see in a second, there's a statutory mechanism for suspending the works where you haven't issued the notice and the client hasn't paid the full amount of the claim. So the consequences are, fairly stark, particularly if you're heading into a contentious contract or a contentious phase in a contract. So the Act also introduces new contractor rights. It introduces a suspension right for non-payment. So I know most contracts have a suspension right, but I don't think any contract has a suspension right with as few as 7 days notice. So 7 days after the failure to issue a payment claim notice, or 7 days after the failure to make a payment, the contractor has the right to suspend the works. One of the questions that I suppose I'm grappling with when we're drafting contracts for people is having two suspension mechanisms. So a lot of, as I said, standard form contracts will have a suspension mechanism, but the Act has a suspension mechanism. And if the two don't talk to each other, I think it has potential to become very confusing. So I would suggest that we actually have to reduce the suspension mechanisms in our contracts to 7 days, because the potential for confusion otherwise is just too great. And then the final point there, a lot of contracts, particularly contracts between main contractors and subcontractors and further on down the tier, had in them a pay when paid clause, or a pay if paid clause. And I suppose that did what it said on the tin. If the main contractor hadn't been paid himself, for whatever reason, he could, under the terms of those clauses, not pay the subcontractor either until he got paid or ever, depending on the drafting of those clauses. And what the Act says is that those clauses are unlawful. And it does, though, carve out a very specific range of exceptions. So where the person who's meant to pay the main contractor goes insolvent within a very tight definition within the Act, the pay when paid clause will float, but otherwise not. So I suppose what are the key points to take away in terms of actually administering contracts? Firstly, ensure that the contract that you have does have an adequate mechanism for determining the date and the valuation, and the mechanism for valuation. Secondly, know your dates. And thirdly, make sure you issue your payment response notice. Now, actually, I missed a point there in terms of knowing your dates, and I just want to skip back to a slide. I said 30 days there, and that looks really obvious, and what most of us read that as is every calendar month. But if you think about it, a contract that's entered into on the 1st of October, a contract with its first payment claim date on the 1st of October, its second payment claim date is going to be on the 30th of October. Its third payment claim date is going to be on the 28th of November. Its fourth payment claim date will be on something like the 26th of January. So within 4 months, you've lost half a week out of your cycle. So actually what we're doing with a lot of clients is putting in 28-day cycles because they make more sense than a 30-day cycle. Does that make sense? That point, yeah. Okay.
Excuse me.
Yep.
I know the Act says that if you don't have a payment, a mechanism for determining the amount of the payment, that you take what's in the Act. But does it actually have the same words about the payment date? Because I think that it may be that when you sign, particularly a subcontractor signs up, his first payment date is 30 days after it started. But in fact, the main contractor's payment date could be a different date altogether, and you could have every subcontractor on the site with a different payment date, and that would make an awful mess.
Yeah, and you're right. And actually, one of the ways that main contractors are handling that, as I understand it, is that they're trying to pin all of their subcontractor payment claim dates to a particular day in the month, at least for the first cycle. So even if the subcontractor has only started on site for 4 or 5 days, they might still be required on the terms of their subcontract to issue a payment claim notice on the first of the month, so that the main contractor can try and get them on some sort of a cycle that feeds in then into what he's on under the main contract.
Yeah, but I think that there's a fault in the Act in that it doesn't specify that the main contractor can do that, and you'll find kind of 10 months into a job, you'll find that somebody's coming up, well, I've been asked to submit my valuation of my payment claim on such and such a date, but in fact my statutory date is a different date.
No,
And it would be helpful if that is the situation, that there was a code of practice that got over that allowed it, once in every job, they must all line up.
Yeah, I'm not sure I agree with that point. I think that Section 4 of the Act does say that if the payment cycle being offered by the main contractor is more advantageous to the subcontractor than what's in the schedule, that's okay. So to my mind, so long as the first payment claim date for the subcontractor is 30 days or less, that's compliant with the Act. So that's the main contractor's opportunity to catch that problem and to fix it, is to make sure that the first payment claim date syncs. That said, there are a lot of the parliamentary draftsman left much open for interpretation in the Act, which is a polite way of saying that there are all sorts of issues with the drafting. So there are holes in. There's no doubt that there are issues with the drafting, whether deliberate or not. One can't presume to know the mind of 166 TDs, but whether the gaps are deliberate or not, I don't know. But there certainly are some curiosities in the drafting. Okay. So I was just wrapping up there in relation to payment, and I was saying that if you ensure that there are adequate mechanisms in your contract, if you know your dates, and if you issue your payment response notices, you'll be keeping on the right side of the law. But what I have said is prepare for the spotlight, because clients are dependent on their consultants to keep them on the right side of the law in relation to this legislation. Like health and safety law, and like a client looks to a PSGP in particular to keep them on the right side of health and safety law, they're looking to you to keep them on the right side of the Construction Contracts Act. And that's the kind of chilling intro into adjudication and dispute resolution. So what I want to do is, rather than giving a full run through what an adjudication might look like, what I'd instead like to do is give a sense of what it might be like to be involved in an adjudication as from an engineering perspective. There are lots of day courses and 3-day courses and 5-day courses out there if you want to go through the line by line of what an adjudication is and how to run one. But as I said, most engineers and architects and people in similar professions are only ever likely to actually get involved in an adjudication once or twice. So I'm kind of more focusing on a sense of what the process is about. So I suppose the first question is really, what has brought us here? And we would all have heard stories over the years of subcontractors in particular having legitimate claims and being told by main contractors that if they choose to pursue those claims, that the main contractor will drag it off into arbitration, and the main contractor will say, probably with some validity, that it'll cost you a 6-figure sum to get this matter to hearing, and sure, the claim mightn't be worth that at all. So very often, subcontractors found themselves with legitimate claims, but having to take a fraction of their true worth because there was no effective dispute resolution mechanism. Arbitration was too expensive and unpredictable, and the High Court, while slightly more predictable, was even more expensive. So what's the change? It's this introduction of adjudication. And what is adjudication? It's what we call a temporarily binding mechanism. So the adjudicator makes a decision in a very tight time frame, which we'll look at in a second, and gives what we call a decision, like an arbitrator's award. And that decision gives a right to payment within 7 days. So the employer has to pay the contractor, or the main contractor has to pay the subcontractor within 7 days of the decision. Now, if either party doesn't like the decision because it has been made in a very limited time frame and so on, without full representation and all the rest of it, they can bring the subject of the dispute on to the dispute resolution forum under the contract, so either onto arbitration or onto litigation. But in the meantime, they have to pay. So the flash to bang time on an adjudication, we'll see, between first getting a notice of adjudication and having to write the check is about 42 days. And if you don't like the decision, you can argue about it, and if you're the employer trying to get money back, you can argue about it at your leisure over the next year or two in litigation or arbitration. So it really shifts the dynamic in terms of dispute resolution, and in terms of giving subcontractors and main contractors access to effective dispute resolution mechanisms. And then I suppose that the implication of it all, there's a much greater emphasis on administration, on getting processes right. And if you get your processes right, you're much more likely to avoid the pain and hassle of an adjudication. And if you do find yourself on the receiving end of an adjudication notice, you're much more likely to be able to manage it. Okay. So this slide here, I'm not going to really talk through it in great detail, but this is just to give you a sense of the mandated timetable for an adjudication. About 42 days from start to payment. Of that, you'll see that only 7 or 14 days belongs to the upstream, to the recipient, to the person who's going to reply. So you're going to get a referral document from from the claimant under the adjudication, and you're going to have between 7 and 14 days to mount your defence. So it really comes back to the whole point of being ready, being prepared to defend in those circumstances. Okay, so as I said, I want to kind of focus on your role. So as I see it, there are two ways of running adjudications, and I did quite a bit of adjudication north of the border. I used to work in Belfast, and typically an employer will make a decision at the outset as to whether he wants the engineer to run the adjudication or whether he wants a lawyer to run the adjudication. And I've seen examples of both working brilliantly, and I've seen examples of both working disastrously. I think it's a horses for courses type decision. There's no right answer. I absolutely wouldn't say to you that every adjudication should be run by a lawyer, but I'd also say that not every adjudication should be run by the contract administrator. One of the real sensitivities about making that decision is that the employer may be wondering if the contract administrator has contributed to him getting into this mess. So there can be this kind of awkwardness about making this decision if the employer suspects that actually there has been a less than perfect compliance with the act on the part of his contract administrator. Whether you're running the process as lead advocate or whether you're the first chair beside the lawyer in terms of running the process, your key task, I suppose, in the first stages is going to be compiling the documentation. You'd be amazed the amount of disputes where people can't find the contract. I have had a matter in arbitration after 2.5 years in discovery and interlocutory proceedings and everything else at a hotel recently demolished around the corner, actually, and I have a vivid recollection of the first day of that arbitration where the arbitrator said, could both sides please present me with what they say is the contract? And one side brought over 3 boxes and the other side brought over 1 box, and both of us said that the contract was complete and contained in that box. So the amount of times that contracts can't be located when they're needed is just absolutely staggering. So know where your contract is. The second thing is correspondence. There's no discovery in adjudication. So one side can't go nosing into the other side's files as they can in litigation or arbitration. But either side can present any sort of documentation that they can lay their hands on. And in my experience of construction projects, it's never the quantity of information that is the problem. I now tend to work more for employers, but the first 2/3 of my career I typically worked for contractors. And typically at the first or second meeting, the contractor would back their Jeep up to the office door and the boxes would start to come in. And it was never the quantity that was the problem. And that was, I suppose, even in an era when the entire electronic discovery for an arbitration could be on a floppy disk. So now we have electronic discovery, or electronic record keeping, electronic correspondence full on. So how you keep your correspondence is hugely important in terms of your ability to manage an adjudication. In these really tight timeframes that we're talking about, if you have really excellent physical and soft copy correspondence files, you will do much better in monetary terms. You can put pounds, shillings and pence against the quality of somebody's file. Immediately as a lawyer coming in to a dispute, I know if I'm going to win or lose substantively when I see how the correspondence is laid out. So just particular issues around that, I suppose. On electronic communications, having a project file is so much to be preferred over everybody having their own inbox. If I hear a client saying, "I'll have the soft copy stuff up to you on a Dropbox or a data site this evening," everybody's searching their inboxes. I know we'll lose the adjudication. Like, it's just that simple, because there's been no coordination. I don't mean to. I'm now starting probably to sound a little bit like an angel of doom or something, but and I don't mean to. But it is that simple. I know that we're going to lose the adjudication if there isn't a project correspondence file, and also the quality of hard copies. Internal records and diaries can be referred to in adjudication, and frequently the best evidence in a construction dispute are people's hard copy diaries. And I don't think that there's a substitute for them. I know some people keep their notes on their Macs and their iPhones and their everything else and their iPads, but nothing. The opposite of everybody having their own emails and not having a project correspondence file is the site foreman walking in with a site diary. And I don't care how bad somebody's handwriting is. Mine is absolutely appalling. I don't care how indecipherable it is, so long as the person who wrote it can read it back reasonably accurately. I don't care if the page is absolutely chock-a-block with notes and there are hand marked scrolls and there are loops from day to day. I don't care about any of that, so long as the person who wrote it down can give a reasonably good account of what's actually in that diary. That will win an adjudication as much as a bad correspondence file will lose it. So, yeah, as I say, the key role that you're going to have is compiling your documentation. After the decision is reached by the adjudicator, there are two things, I suppose, that fall out for the consultants who are advising. The first is to make sure that your client has arrangements made to make a payment within 7 days. A lot of our international clients, for example, when they're drafting construction contracts, and we say, "Oh yeah, clause 35 of the RAI, you have to pay 7 days after the certificate is issued," or is it 7 or 5? I always get it mixed up. It's one or the other. One is for the certificate and the other is for payment. And they say, "No, we can't. We are insert name of big company here. We can't do this. We don't do this." Well, in the case of an adjudication, if they don't make payment within 7 days, they're going to find themselves in the receiving end of a suspension. And the thing is, in my experience, when things have gotten as bad as that there's an adjudication on a site, there will be a suspension. You might say a contractor will never suspend, but actually, if they've gone to the bother of instituting an adjudication against their own client, they're going to suspend the work so they don't get paid within 7 days. So making sure that you have proper making sure that your client, or encouraging your client to make provision for a rapid payment is a part of your role in terms of advising them. The second thing is that, as I mentioned, the adjudicator's decision is only temporarily binding. Now, it has been described in the UK as rough justice, So judges in the Court of Appeal have said that decision is barmy, but it's rough justice. This is what adjudication is about. The vast majority of adjudications actually become fully binding because the parties never do anything about them. Adjudicators might never have heard of the project before they got the notice of adjudication or before they got the referral document on their desk, but they tend to be construction professionals of 20, 30 years experience, and they tend to get it about right. Here I open another gender conundrum. All of the statutory adjudicators are men. The minister didn't appoint any women to the panel, but there you go. That's maybe a drum for a different day. The adjudicators tend to be able to get it right, more or less, in my experience. In the UK, the Glasgow Caledonian University keeps stats on adjudications and who starts them and who wins and what their outcomes are and so on. And they reckon about 80% of adjudications never go any further than the adjudicator's decision, so the client pays up on foot of the decision. Of that, another 17 or 18% have proceedings issued or arbitration commenced or whatever, and they die within 6 or 7 weeks, typically. So the adjudicator's decision, plus a bit of pressure, oh, I'm really going to litigate or I'm really going to arbitrate, is enough for the matter to settle. Maybe on slightly different terms to the adjudicator's decision. And only 2 or 3% of disputes actually go all the way to litigation or to arbitration. And bear in mind that in the UK they have a far better court system. They have a specialised technology and construction court system that just exists to hear mainly construction disputes, where judges actually know what a final account is and so on. So after the decision's reached, you'll be involved in that decision about whether to litigate or to arbitrate. And what I'd say as a general rule of thumb is, if the decision is roughly right, accept it and move on. Okay, so in terms then of preparing, much of the initial work in adjudication is carried out by the referring party, and typically, as I said, that tends to be the contractor or the subcontractor. Another little Glasgow Caledonian stat: 80% of adjudications are substantively won by the party who initiated them. So it is, it is a slightly tilted process. Identify the signs. There's a lot of talk about adjudication being an ambush and the 42-day period, and they come at you from nowhere, and they come at you on Christmas Eve, and you get the notice of adjudication on Christmas Eve, and blah, 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 blah. Well, actually, in my experience, I've never had an ambush adjudication, and I've had my fair share, I've been involved in my fair share of adjudications. They never come out of the blue. You know that they're coming. The day or the hour might be a bit of a surprise. You might have thought that you were still talking to them about it or whatever, but the fact that you were in dispute is never a surprise. So getting your homework done, if you don't have your perfect correspondence file, that's the time to do it. Identifying the dispute early, very important. And so too is lining up the people that can assist you with it. So if it's a legal dispute, getting your lawyers on board. If it's a technical dispute and you're going to need an expert, getting your expert on board before the notice of adjudication ever arrives near you. And the final point, I think I've said it more than enough about. So I suppose, by way of summary, the same lessons can be applied to both the payment process elements of the talk and the adjudication elements of the talk. There's a focus on administrative processes. Being alert, watching for your payment claim notice dates, watching for the signs of an adjudication coming at you, watching for correspondence changing in its tone. And I suppose the final point is, if in doubt, to check. This is a new act. None of us know it so well that we wouldn't say that we could do with knowing it a little bit better. So if in doubt, check back to the text of the act or to any of the explanatory materials that are on the internet. Some of them of better quality than others, it has to be said, but there's a lot of material out there on the act. So I suppose I hope I haven't been too gloomy in terms of the talk that I've given. I'm just to think about time to wrap up. What I said at the outset is that I hoped that we would kind of give you the ability or give you the information that you need to be able to administer contracts and avoid disputes. And I think that's really what it's all about. So I hope that we've achieved that in the last 40 minutes or so. Very happy to take questions. Oliver, you're going to preside over questions? Very good. And microphones and everything else. So there you go. So thank you very much.
Thanks, Robert. We'll open the questions to the floor. There's a roving mic that'll run around. We do have a number of viewers online, so I'll just wait. If you could just wait till the microphone arrives at the first question over there. Ali, the gentleman in the blue shirt.
Vernon Pilcher. I'm a program scheduling consultant, and I'm working on client side for some capital projects in Dublin. It's a selfish question first, I'm afraid. I make half a living preparing as-built programs for dispute resolution, perhaps in relation to JCT type contracts, and they take a considerable amount of time to prepare. Is that service now redundant in this 42-day scenario, or is there still a place for the as-built program in relation to the time aspect of dispute resolution?
I have strong views on programs in disputes. Yeah, I think there's still a place for it, but I think that you're not going to have the time to prepare the all singing, all dancing, Primavera or whatever it is, and the adjudicator is not going to have time to get his head around it. So I would say you're back to Gantt charts. You're back to like the most beautiful delay analysis that can be presented is in probably no more than 20 bars. And I know you're going to say to me that's just beyond imagination. But bear in mind that the decision maker is never going to have heard of your project before the dispute lands on his desk, is not going to be a programming expert, and is going to be relying on baby steps. And you're going to have lawyers possibly on both sides as well, and they're certainly going to be relying on baby steps and very simple programs. So I would say, there is still a space for as-built programs, but in the context of adjudication, if you don't have one to hand, and even if you do, I think everybody would prefer to see the Ladybird variety rather than the War and Peace variety. I hope I haven't caused too much controversy with that statement.
No, that's very good. Thank you.
Any other questions?
How are you doing? I've worked for both main contractors and subcontractors, and your comment on the 21 days to go back regarding the notice, you were saying that it's just from a sub-E point of view, and even from a main contractor to a client point of view, that if you miss the 21 days, you have to pay the full value of a claim. How does that work if a sub-E is, we'll say, overclaiming on a monthly valuation, and it causes maybe I see in a lot of organisations where surveyors maybe go on holidays, and there might be a changeover. He might be missing for 2 weeks. My claim might be maybe 50 grand over in his eyes. So do they in turn have to pay the full value of that?
The answer, I think, and this is, the Act isn't clear on this, and this is one of the problems I was referring to, but I think the answer is yes, you have to pay out the full amount of the claim. But I think that's a little bit more dramatic than it sounds, for two reasons. One is, if an employer came to me in a circumstance where that had arisen and they were about to have a penalty kick of a summary judgment, summary judgment was going to be served on them, I would say, this is really unfortunate. You're going to get your summary judgment. Hunker down. Make sure you get your next notice out on time. That's the cure to it. Now, the trouble with that, though, is that on contracts where there is where that has been allowed to happen once, in my experience of looking at this in the UK, it happens a number of times, and actually the payment cycle has fallen to bits, and there's an adjudication in there somewhere if the guy wants to go to adjudication. I wouldn't want to suggest that every main contractor is going to be running out with a summary summons because a QS that they're essentially getting on with is a day late on evaluation. But the culture or the climate in the UK has changed, so the evaluations are done on time. But what you need to know is how to keep yourself out of trouble where you have a contentious contractor or a contractor that's maybe setting you up for it.
Just one other question. Where it actually goes to adjudication, you were saying internal diaries were a great form of sorting things out. If I keep an internal diary, obviously I can put whatever I want. That's an undocumented, we'll say, piece of paper, and it's not going to be signed off by the other party. So what I say, how legit is that, or do you know what I'm saying?
Yeah, no, I do. I mean, the best form of record is a contemporaneous record, and then contemporaneous records come in really two categories. One is the type of record that's sent to the other side, so, or signed off on by the other side. So emails are a contemporaneous record. Further to our site meeting this morning, I confirmed that, blah.
Yeah.
Or getting inspection sheets signed off, that sort of thing. They're contemporaneous records. The other type of contemporaneous records are those that don't go to the other side on the day. And what they go to in the most formal dispute resolution forum, which is court, is that the person who wrote those notes is entitled to rely on them when they're in the witness box. So that's why you always see Guardi like diligently writing everything down. If they don't write it down on the spot, they're actually not entitled to rely on it. But in adjudication, or even in arbitration, it is very common to have the whole site diary photocopied and put into the bundle, put before the adjudicator. He's entitled to take a more expansive view of what's admissible and what isn't. But what I'd say is, even the scrappiest site diary with the worst handwriting, if it was kept on or about the day in which the thing happened, is so much more preferable to a report that the same person has written 6 weeks later or 8 weeks later. The level of detail and the level of reliance that an adjudicator will put on it is much greater. So I'd say site diaries have a value. By way of I thought where you're going is, well, do I have to give it up? And I do recall an arbitration that I had a number of years ago, where very sadly the person involved was also going through marital difficulties, and he was keeping a site diary, but he would also note things like whether his wife had called him or not, and whether he'd seen his children that day. And I know that sounds, I mean, it is heartbreaking stuff, but the same site diary became evidence in 2 sets of proceedings, in an arbitration that we were running and in a family law proceeding. So there you go. Anyway, that's an off-topic comment.
Thank you.
We'll take one more question if there's anybody in the audience. No, we have one more.
Sorry. Are there any downsides to bringing a claim, as in penalties for losing one, or frivolous, or wasting people's time?
No, there aren't. Apart from the parties have to bear their own costs, so I suppose the claimant has to bear its own costs. But here's an idea, again, a frivolous idea, but one to throw out by way of diversion. A colleague of mine has suggested that what we should do is deduct. In cases, obviously, if you're on for the employer, I have an entirely different view of them on for the contractor. If you're on for the employer and you're afraid that a contractor is going to make frivolous or vexatious claims, that you could charge them a percentage of the amount of the claim that hasn't been borne out by way of an administration fee for having to run the claim. Now, if somebody wants me to draft that clause and will pay me for it, I'd be delighted to do that. But no, the straight answer to your question is that there's no mechanism. And actually, I would go further. In court, you can go in and get what's called an Isaac Wonder order. You can go in and get an order saying that this person has taken claims against me 3 or 4 times, and they're a cranky neighbour or whatever. I want it to be so that they can never take another claim against me without the explicit leave of the court. But you don't have that in adjudication, actually. You could have a claimant who could put you through the mill any number of times, and there's no mechanism. I mean, your question makes me think about this, that there's actually no mechanism for cutting off vexatious claims in adjudication. We've one more, and then Owen, do you have no question at all?
Sorry,
I'm being cheeky now. I'm more than happy to hang around, by the way, and deal questions one-on-one, but shall we take one more?
Right, my name is Fergus Cooney. I'm a contracts manager and I've been dealing with claims for about 20-something years. The answer to your last question is actually the adjudicator's fee. In the event of a frivolous adjudication, the adjudicator can decide who pays his fee in full, and he can ask the person with the frivolous claim to pay it in full, and that will stop him the second time. You mentioned that there were some forms available on a website. What website is that?
I think it's the Department of Enterprise, Trade and Employment, or whatever it's called now. Department of Enterprise website.
Right, and the other point to make about site diaries, it's very, very easy to know which site diaries are contemporaneously written and which ones are the few pages that you need were written up in retrospect.
Absolutely, yeah. There's no doubt about that.
Okay, just thank you, Robert, for that. Just a few housekeeping issues then to finish up. Our next lecture is on the 9th of November, and the notices will be sent out. You'll all get them via the email as well. Just to thank the committee who were involved in asking Robert to do that presentation this evening, to our PRO Ali Gleeson, to our secretary Deirdre Neff, and to our vice chair Donald Minnock, who couldn't be here this evening. Finally, I'd just like to call on Owen O'Cahine to give the vote of thanks.
I decided to wait until I got the mic unchallenged. No, I'd just like to thank Robert for coming here tonight and giving a nice, succinct and clear presentation on this new act. It's obviously something that the whole industry is going to have to get to grips with over the next while, and I suspect there are aspects of it that will only become clear as certain things are brought through the process and as we go along and as certain things are challenged. Or it's very useful always to bring us back to the basics that applies in any such processes, and it's a timely reminder of all that. I thought the presentation material was very clear. I thought the presentation was very engaging, and I think we'd all agree that Robert is a very engaging presenter, and the little anecdotes and experience brought into it is helpful in explaining everything he said. So look, I'd just like to thank Robert personally, and I'd like to ask everyone else here to show their appreciation in the usual way.
That's it for this evening, so just to thank everybody for coming.